Imagine you fire an employee for egregious sexual harassment.
Right.
You have all the evidence, the chat logs, the witness testimonies, a meticulously documented internal investigation.
The whole package.
Exactly. You let them go, confident you did the exact right thing to protect your team. But a month later, that exact same former employer uses a brand new digital privacy law to legally force your company to permanently delete all evidence of their misconduct.
Wow.
Right. And if you refuse, well, your company faces crippling financial penalties. Welcome to the massive silent collision happening in corporate law right now. Today, we are exploring a vicious turf war between workplace safety and data privacy.
It really is a massive blind spot. I mean, if you follow legal news, you probably know about the highly public clash between the new Digital Personal Data Protection Act, the DPDPA of 2023, and the Right to Information Act.
Yeah, that one has definitely been in the headlines.
Exactly. That conflict has already been flagged and is currently being battled out in the Supreme Court. But this scenario you just described, that is the silent conflict, the friction between this new data protection law and the POSH Act.
Right. And our mission for this deep dive is to really map out this exact intersection for you before your company or your specific department gets caught in the crossfire. Because whether you are a CEO, an HR manager, or just an employee navigating the modern workplace, this legal paradox is going to fundamentally change how corporate investigations are handled.
Oh, absolutely. It changes everything.
Okay, let's unpack this. Before we can really understand why these laws are crashing into each other, we need to understand the foundation of the first law, the POSH Act of 2013, which is the Prevention of Sexual Harassment at the Workplace. So if an employee comes forward with a complaint today, who actually handles it? I mean, is it just standard HR?
No, and that distinction is incredibly important. The POSH Act actually removes these investigations from standard management hierarchies. It mandates that any organization, public or private, must constitute a highly specific internal committee to receive and handle complaints.
Wait, so you can't just assign a couple of available managers to look into it?
Not at all. The law dictates the committee must be presided over by a senior woman employee. It needs at least 2 other employee members. And crucially, it must include 1 external member.
Wait, an external member? Why the external member? I would think a company would want to keep an investigation entirely in-house to, sort of manage the fallout.
Right, but that instinct to manage the fallout is exactly why the law requires an outsider. The external member is usually someone from a non-governmental organization or someone with a legal background in workplace harassment. Their entire purpose is to break the corporate echo chamber.
Oh, I see.
Yeah, think about it. If a junior employee accuses the company's top-performing sales director of harassment, well, there is a massive financial incentive for the CEO and standard HR to protect that high earner.
Right, because they're bringing in the money.
Exactly. So the external member is there to neutralize those power dynamics and prevent internal cover-ups.
That makes perfect sense. So the company has to set up this independent committee, but what else does the law demand of them operationally? I imagine it's not just setting up a desk and waiting for complaints.
Oh, far from it. The POSH Act casts very heavy, deliberate obligations on the employer. They are legally mandated to actively ensure a safe working environment. That means they have to adopt a clear POSH policy, communicate it constantly to all employees, and conduct regular training programs.
So it's a very proactive mandate.
Yes. They also have to provide the internal committee with all the logistical and administrative assistance they need to conduct interviews and gather evidence. The company has to formally recognize sexual harassment as misconduct in their corporate rules, impose strict penalties when it occurs, maintain meticulous records of all proceedings, and file annual reports with the government.
Wow, that's a lot of documentation. But reading through our sources, it seems like the absolute bedrock of all these mandates, like the thing that holds the entire POSH framework together, is confidentiality.
It is the absolute linchpin. Organizations must ensure total confidentiality, support, and protection for the complainant. And that isn't just a suggestion, right? It is a strict legal requirement.
Because if it leaks, the whole system fails.
Exactly. If the identity of the person coming forward or the specific details of their testimony were to leak to the broader office, the entire system collapses. Retaliation is a very real, very dangerous threat in these situations.
Right. Think of the POSH internal committee like a corporate witness protection program. Its entire success hinges on absolute secrecy, trust, and safety for the accuser. Because if an employee doesn't deeply believe the company can keep their testimony locked down, they are just going to stay quiet.
The witness protection analogy is close, but there is a major catch.
What's the catch?
Well, in a federal witness protection program, the government hides you from the person who wants to hurt you. But in a POSH scenario, your own employer, who is actively paying the salaries of both you and your harasser, has to hide you.
Oh, wow. Yeah, that's a wild conflict of interest.
It is. That is a much, much harder dynamic to manage. POSH recognizes the severe power imbalance in almost every harassment case. The strict record keeping is there to ensure due process for the investigation. But the extreme confidentiality is there to ensure the complainant can actually survive within that corporate ecosystem.
Right. So the law essentially says we will document everything to serve justice, but we are going to build an impenetrable fortress around those documents.
Yes, exactly. A fortress.
Okay, so we have our fortress, a legal mandate requiring highly sensitive record keeping paired with extreme secrecy. But what happens if the accused simply walks up to the fortress and demands the master key to their own file? Because before 2023, HR could just say no, but then came the DPDPA.
Exactly. The DPDPA 2023, the Digital Personal Data Protection Act, is designed to grant sweeping transparency and control to citizens over their personal data in the digital age.
Right.
It dictates that if an organization holds your personal data, you have fundamental rights regarding how that data is used, stored, and processed. And in the context of a POSH investigation, the person accused of harassment is legally referred to as the respondent.
And naturally, a POSH investigation file is going to be absolutely packed with data about the respondent. It's going to have their name, their personal emails, detailed testimonies about their behavior, timestamps of where they were on certain dates. I mean, it is essentially an entire dossier of their personal information.
It really is.
So under this new law, what exactly can the respondent do with that?
Well, they gain a tremendous amount of leverage. Under the DPDPA, the respondent has the right to demand disclosure. They can formally ask the company, what personal information do you hold on me and exactly how are you processing it?
Right.
Furthermore, they have the right to request the deletion and correction of that information. If they feel their data rights are being violated, they have the right to escalate the issue through a formal grievance redressal system.
Wait, I need to stop you right there. Let me just play devil's advocate for a second. If a law is designed to protect my digital privacy, does that mean I get absolute control over all data about me, even if that data is like an objective record of my own terrible behavior?
Yeah, it's a great question.
Like if I harass a colleague and the internal committee documents my actions, can I just invoke my data privacy rights to manage or erase that documentation?
What's fascinating here is the inherent paradox of modern legislation. The DPDPA does not have a moral filter. It doesn't inherently distinguish between good data, like your standard salary slip or your home address, and bad data, like a detailed record of a harassment complaint against you.
It just sees data.
Exactly. It just sees personal data. So we have a law meant to protect citizens' digital rights operating in the exact same physical space as a law meant to punish workplace misconduct.
That's wild.
Theoretically, yes, the privacy law gives you the right to control how your data is processed, which creates an agonizing legal dilemma when that specific data is the core evidence of a workplace crime.
Here's where it gets really interesting. Let's bring these two forces together and look at the actual operational conflict, because this isn't just, an abstract debate for law school. This is going to play out in real conference rooms and email chains.
Oh, it already is.
Right. Let's look at a scenario where the respondent's data rights actively threaten the complainant's safety. How does this collision actually look on a Tuesday afternoon at a mid-sized company?
Let's walk through the mechanics of it. Under POSH, an employee files a complaint. The internal committee starts quietly gathering evidence. They are interviewing witnesses, collecting emails, building this highly confidential file.
Okay.
But under the DPDPA, the respondent might suspect something is going on. They haven't been officially notified of the POSH complaint yet, but they send a formal request to the company's data protection officer, demanding full disclosure of how their personal data is currently being processed.
So they basically cast a massive net, like, tell me everything this company is doing with my name right now.
Yes. Now, the company faces an impossible choice. Does the company disclose that an internal committee is currently processing their data for a harassment investigation?
If they do, they instantly breach the absolute confidentiality mandated by POSH. They tip off the accused and potentially endanger the complainant, inviting retaliation.
Exactly. But if they don't disclose it, they are actively violating their respondents' rights under the DPDPA. And violating the DPDPA can result in massive multi-million-dollar financial penalties from the Data Protection Board.
That is a nightmare scenario for any executive.
Yeah.
And it goes beyond just asking for disclosure, right? We mentioned deletion earlier. How does a deletion request actually work when these two laws clash?
That is the second massive point of friction. Let's say the DPO, the data protection officer, receives a formal request from the accused respondent demanding the deletion or correction of the HR files that contain the victim's confidential testimony.
Wow.
The respondent might argue, this testimony about my behavior is wildly inaccurate. It's my personal data, and under the DPDPA, I demand you correct it or erase it.
It's like a bank vault being audited.
Yeah.
POSH demands the vault door stays permanently locked to protect the vulnerable person inside, but the DPDPA gives the accused the master key to walk in and inspect or destroy the contents.
That's a great way to put it.
Which creates a direct, brutal turf war between two key corporate figures. In one corner, you have the HR manager, who is legally mandated by POSH to protect these records and shield the complainant at all costs. And in the other corner, you have the DPO, who is legally mandated by the DPDPA to strictly comply with the accused's data transparency and deletion request within a really tight legal window.
Precisely. And they are legally required to do opposite things. The HR manager knows their job is on the line, and the company is liable under POSH if they leak or destroy the file.
Right.
The DPO knows their job is on the line, and the company faces massive DPDPA fines if they withhold the file.
So could an accused harasser intentionally weaponize their privacy rights under DPDPA to legally force the DPO to delete the evidence against them before the HR manager can even finish the POSH investigation?
That is the ultimate fear.
Yeah.
Usually, broad privacy laws like the DPDPA have exemptions carved out for legal proceedings or formal state investigations.
Oh, okay. So there is a loophole.
Well, yes, but the boundaries of those exemptions are incredibly murky when applied to internal corporate committees rather than official police investigations. A DPO might look at an internal POSH committee and say, "You aren't a court of law, you are just a company panel. I have to honor this employee's data deletion request."
Oh, wow.
It is a massive gray area that a bad actor could absolutely exploit to destroy evidence before it ever reaches a real courtroom.
And as if this internal tug of war wasn't complicated enough, we have to layer in the reality of the modern digital workplace. Harassment today rarely looks like it did 20 years ago. It's not just a physical advance or a comment made by the water cooler.
No, not at all.
It leaves a permanent electronic trail. We are talking about late-night Slack messages, inappropriate WhatsApp texts, explicit emails, and the sources show us that this digital reality brings in a whole new set of complex legal mechanisms.
It really does. When the evidence of harassment is digital, several additional legal frameworks suddenly impact the rights and safety of the POSH complainant. First, you have the ITA 2000, which is the Information Technology Act. Specifically, the sections regarding obscenity in electronic documents.
Right.
If the harassment involves an employee sending explicit images or sexually colored digital messages to a colleague, it immediately crosses the line from a simple corporate policy violation into a potential criminal violation under the IT Act.
Our sources also mention the BNS, the Bharatiya Nyaya Sanhita. How does that factor in?
The BNS contains specific provisions regarding cyberstalking. So if an employee isn't just making a one-off comment, but is repeatedly messaging another employee across different platforms, monitoring their online status or tracking their digital presence after being asked to stop, that elevates the situation entirely.
It's no longer just workplace harassment.
Exactly. It triggers criminal cyberstalking statutes.
Okay, but if someone is cyberstalking me on Slack, can't I just take a screenshot on my phone and show it to the internal committee? I mean, why is it more complicated than that? And I guess that brings us to the third acronym in our sources, the BSA.
Right. The BSA is the Bharatiya Sakshya Adhiniyam, and this is where things get highly technical. This law deals with the certification of electronic evidence. Under the BSA, you cannot just print out a screenshot of a WhatsApp chat from your personal phone and hand it to an investigative committee.
Wait, really? Why not? A picture is a picture, right?
Because digital images can be easily manipulated or photoshopped. To be legally valid as evidence, especially if the POSH case escalates and goes to an actual court, that electronic evidence has to be formally certified.
Oh, I see.
This means providing the technical metadata, the hash values, and the device logs to definitively prove the chain of custody and guarantee the screenshot hasn't been tampered with. If an employee just snaps a photo of their monitor with their personal phone, the chain of custody is broken, and it might be dismissed as hearsay.
So what does this all mean for you? If you are a mid-level manager or a team lead listening to this, why should you care about this highly technical web of the ITA, the BNS, the BSA, and the DPDPA. It sounds like a headache purely for the legal department.
If we connect this to the bigger picture, it means that a single inappropriate message sent over a company chat app at 11:000 p.m. doesn't just trigger a standard POSH complaint anymore. It is no longer just a localized HR issue.
Right.
The exact second that one digital message is sent, it simultaneously triggers potential cyberstalking laws, requires strict electronic evidence certifications to be valid, and initiates a deeply complex web of data privacy rights for the accused. The landscape of workplace behavior has been fundamentally digitized and legalized to a degree we haven't seen before.
The actionable takeaway here is that you have to stop playing amateur detective. If you are a manager and an employee comes to you saying a colleague is sending them inappropriate texts, your instinct might be to say, just send me a screenshot of what he said and I'll talk to him quietly.
Yeah, that's a very common reaction.
But the second you do that, you are actively creating a massive liability. You might be inadvertently violating evidence certification laws under the BSA, breaching the strict confidentiality mandated by POSH, and triggering a data privacy nightmare under the DPDPA by mishandling the accused's personal data on your own device.
Exactly. The era of casually resolving workplace disputes with a quiet conversation is over. The intersection of these laws creates a highly volatile environment. Well-meaning actions by untrained managers can result in severe legal liabilities for the entire company. You have to escalate it directly to the officially mandated internal committee immediately.
To summarize this incredibly dense landscape, the core realization here is that the intersection of the POSH Act and the DPDPA is a silent collision waiting to happen in almost every major company. We have a legal ecosystem that is actively pitting the vital, life-saving confidentiality of harassment victims against the newly minted, legally binding data rights of the accused. It leaves HR managers and data protection officers trapped in the middle of a high-stakes tug-of-war, with both sides facing severe penalties if they make the wrong move.
And the inherently digital nature of modern evidence makes it worse. Governed by the IT Act, cyberstalking provisions, and complex electronic evidence rules, the data is simultaneously more critical to rigorously preserve and far more difficult to legally protect from deletion requests.
Which brings us back to our mission for this deep dive. Understanding this massive blind spot puts you ahead of the curve. Whether you are an employee wanting to understand exactly how your own digital safety and data are balanced, a manager trying to safely navigate team disputes, or just someone fascinated by how good intentions in law can create chaotic real-world paradoxes.
Right.
You now see the underlying mechanisms. You know exactly what's happening beneath the surface before the collision actually occurs.
It's a vital reminder that legislation does not exist in a vacuum. Every new law ripples outward, often crashing into existing vital structures in completely unforeseen ways. The corporate world is going to have to do a lot of rapid, very careful evolving to survive this particular intersection.
Now, before we wrap up, I want to leave you with one final, deeply provocative paradox to mull over. Something from the source material that genuinely surprised me. Earlier, we walked through the DPDPA and the sweeping data rights it gives to the respondent. But the law goes a step further. It extends those data rights to the nominees of the respondent.
Yes. A nominee in this legal context is usually a family member, a spouse, or a legal heir.
Wait, so nominees literally inherit your data rights?
Under the current framework of the DPDPA, yes, they do.
That is wild. Okay, so imagine this scenario. An accused respondent is going through an ongoing, highly sensitive POSH investigation. There are incredibly damaging, strictly confidential testimonies from multiple victims on file. Suddenly, the accused respondent passes away before the investigation concludes. Do their surviving family members, their nominees, suddenly inherit the legal right to access, disclose, or even demand the deletion of the highly confidential testimony of the living harassment victims?
It's the ultimate gray area. The family could invoke the DPDPA to demand the files to clear their loved one's name, while the company is bound by POSH to protect the victims who are still working there.
How does a company possibly balance the inherited, legally binding data rights of the deceased against the safety, anonymity, and psychological well-being of the living? When the vault door is finally forced open by a grieving family, whose rights get swallowed up first? Keep that in mind the next time you think a new corporate data policy is just harmless paperwork.